got a big day ahead of us, and we want to get underway so that we can get everything in. And we've got a little business to take care of first. And Rich, if you could please call the roll.
I will. Thank you. Chairman, Representative Kelly present. Vice Chairman, Representative Hoheisel present. Ranking Minority Member, Representative Hsu is present. Representative Anderson is present, remote. Representative Baker is present. Representative Bergkamp present. Representative Day present. Representative Donahoe, I've not seen quite yet. Representative Finney is present. She is remote. Representative Kessler. Representative Lynn is present. Representative Neely. Representative Poskin is present. Representative Samsel is present, remote. Representative Topliker. Representative Wassinger is present. Representative Weigel, I believe, is on his way.
Thank you, Rich. Next item, a quick item of business. We have some meeting minutes that were sent out to you, February 8th, 10th, 15th, 17th, 22nd, and 24th. And if you've had time to review those, we'd like to entertain a motion to adopt those minutes. Have a motion, Representative Wassinger. Second, Representative Hsu. We have the motion and a second. All those in favor, please signify by saying aye. Opposed, nay. Minutes are adopted. So today on our hearing, it's going to be jam-packed, and we want the process that we'll go through is like normal. It's on House Bill 2398, and the first would like to have our reviser, David, to kind of give us a review of this bill. David.
Thank you, Mr. Chairman. Good morning, everyone. House Bill 2398 would enact the Technology-Enabled Trust Bank Act. This would be a new act that would consist of 27 new sections of law to be part of the banking code, or Chapter 9 of the Kansas Statutes Annotated. It would also establish a new tax credit section that would be part of the Kansas Income Tax Act. The act has created a new financial institution under Kansas law known as the Technology-Enabled Trust Bank, or Trust Bank for short, and it would be under the supervision of the Office of the State Bank Commissioner. Just kind of going real quickly through the bill, Section 1 is the citation and provides various definitions of terms relating to the act. Section 2 is the section that requires that the trust bank obtain a charter from the state banking board before they can conduct any business. There's also the board may require fingerprinting and a criminal history record check of officers, directors, or other persons associated with the bank. And then the actions of the state banking board in approving or disapproving a trust bank application would be subject to review in accordance with the Kansas Judicial Review Act. This section also does provide that a trust bank is required to make a distribution of cash or other assets to both the Department of Commerce and to one or more qualified charities. Section 3 establishes the fee structures for trust banks. There would be an initial fee of $500,000. If there's an inactive trust bank, it would be an amount not to exceed $10,000. Those fees would then be split 75-25 between the Bank Commissioner Fee Fund and a newly created fund in the Treasury, the Technology-Enabled Trust Bank Development and Expansion Fund, which would be under the Department of Commerce. That's specifically created in Section 24. We'll get to that in a little bit. There's also then assessments of examination fees for when the Bank Commissioner and his staff need to conduct examinations. This establishes a fee structure for those assessments on the trust banks as well. Section 4 just says that the provision of the state banking code apply to trust banks in the same manner that the provisions would apply to trust companies unless specifically exempted within this act. This also incorporates certain trust bank terms and terminology than a definition of terms defined in the banking code currently. Section 5 is capitalization requirements for trust banks. Section 6 is kind of establishes what the trust bank's board of directors would look like. The board would have to be managed and controlled by a board of directors of at least 5 and not more than 25 members. At least one of the directors must be a resident of Kansas. And then there's also lays out kind of the requirements relating to the board meetings, any director vacancies, requiring director oaths. Section 7 requires the trust bank to make report to the commissioner concerning transactions pursuant to generally accepted accounting principles, and in calculating the trust bank's capital solvency. The section also provides standards for the commissioner to evaluate a trust bank's safety and soundness, much in the same way the commissioner would examine a bank or trust company. Section 8 kind of describes what trust bank's name or advertising could consist of. They can use words trust company, or trust bank, or similar term or phrase, but can't just say bank or another term that implies that they're holding themselves out to the public as in the business of banking, unless the commissioner approves any such use. Section 9 requires that the trust bank would maintain office space in an economic growth zone. This is defined in the Act there in Section 1 as a community with a population of 5,000 or less, and would be located in any of the current rural opportunity zone counties, or Harvey County, which is also added as an economic growth zone in this Act. And they would have to employ, engage, or contract with at least 3 employees to provide services for the trust bank in Kansas. And those employees would have to facilitate any examinations that are required by the Act. Section 10 provides a trust bank with authority to exercise powers relating to FID-FIN or fiduciary finance transactions. It's a term that's defined in the Act. And then receiving or managing alternative asset custody accounts and engaging in trust business. Section 11 also provides some powers, duties, and responsibilities relating to financing or credit, extending financing and credit to those FID-FIN trusts. Section requires distributions in an amount equal to 2.5% of the trust bank's transactions during the calendar year. The distributions would be made to the Department of Commerce in that same manner as is seen in Section 2. Section 12 allows trust banks to employ various professionals, advise and assist the trust bank in performing the business. Trust banks are also permitted under the section to employ agents to perform acts of the transactions, custodial services, or trust business, and to license internet services, software, mobile applications, technology-enabled platforms and processes to or from affiliates, third parties, or other trust banks. Section 13 allows the trust bank to serve as a custodian, an asset custody account, and establishes the requirements the trust bank shall satisfy in performing those services. Section 14 provides some of the powers of the trust advisor. They could have some, none, or all the rights, powers, privileges, benefits, immunities available to a trustee under Kansas law. Unless the instrument provides otherwise, the trust advisor would have no greater liability to any person than would a trustee holding or benefiting from the rights or authority provided or allowed by the instrument that creates the trust to such trust advisor. Section 15 exempts fiduciary from liability, either individually or as a fiduciary, for any loss that results from compliance with the direction of the trust advisor, or that results from failure to take action proposed by the excluded fiduciary that requires the prior authorization of the trust advisor. If there's an action to try to attempt to assign liability to the fiduciary, the burden of proof would be on the person seeking to hold the fiduciary liable, and it would be under the clear and convincing evidence standard. Section 16 provides that a trust advisor is presumed to be a fiduciary when exercising the trust advisor's authority under this act. Section 17 exempts an entity appointed as a trust advisor from provisions of Article 8 of Chapter 9 of the Kansas Statute upon satisfaction of those specific conditions that are listed in that section. Section 18 provides that an instrument may relieve and indemnify a trust bank serving as trustee from liability for breach of fiduciary duty if any such provision is unenforceable to the extent that it relieves the trust advisor or trust bank from liability for a breach of fiduciary duty committed in bad faith, intentionally or with reckless indifference to interests of a beneficiary. Section 19, this governs the compensation of trustees under these trusts. Section 20 is a privacy section. So if there's any court proceeding upon a petition by the acting trustee, custodian, trustor, or any beneficiary, those records can be sealed by the court and not be made part of the public record of the proceeding. Section 21 provides that a trust bank may file forms relating to trust bank transactions under the Act with the bank commissioner for examination, review, and approval, and describes the time frame that the commissioner has to make such approval or disapproval of the forms. Section 22 requires the commissioner to adopt rules and regulations on or before January 1st, 2022 to administer the Act. Section 23 provides that no maximum interest rate or charge or usury rate restriction shall be applied between the trust bank and the trust if the interest rate is established by written agreement between the parties. Section 24 establishes that this is the trust bank, the technology-enabled trust bank development and expansion fund. This would be in the Treasury, administered by the Secretary of Commerce. So this is where those distributions would be deposited. Expenditures from the fund shall be for the purpose of promoting and facilitating the development and growth of trust banks, FinFin activities, and custodial services in Kansas, and to locate trust banks office space in an economic growth zone. The fund is also eligible to receive interest earnings. Section 25 requires that on July 1st, 2021, the commissioner would grant a trust bank charter to beneficiate trust bank and shall establish a pilot program with beneficiate trust bank, and then provides a specific initial fee and distribution requirements for beneficiate under the pilot program. Harvey County, a community within Harvey County that would be selected by beneficiate would be the first economic growth zone under this pilot. Section 26 provides that no interest held in a FinFin trust shall be void or invalid by reason of any common law rule. Section 27 provides that for state tax purposes, a trust bank, their classification would be as determined under the Federal Internal Revenue Code. So whatever their federal status is would be their state status. And then Section 28, this is the income and privilege tax credit that would begin tax year 2021. And it would be for the amount of the credit would be equal to such trust bank's qualified charitable distributions during the taxable year if the bank maintains the principal office in an economic growth zone. This credit can be carried forward for up to 14 additional years following the first taxable year the credit is allowed. And then the bill would take effect upon publication in the statute book July 1st, 2021. I would also point out that there is a typo in the bill. It's actually on page 9, line 6, and subsection H there. It describes a Rust bank, not a trust bank. So that's just a typo there that would need to be corrected at some point. But there's a lot going on in this bill. I think there's some components that can really get into the nuts and bolts of these trust banks. So I'll let them really describe the process. Probably they're the experts. But I can stand for any questions about where things are at in the bill or anything on the bill brief.
Any questions for David? Representative Burkamp?
Thank you, Mr. Chairman. David talks about the pilot program. So essentially, the commissioner is going to grant them a charter on July 1, and then they can't do any FinFin transactions until December 31, or the commission adopts the rules and regulations. Is there a place where it gives the legislator or anybody a chance to go back and review that? Since it's a pilot, I anticipate maybe like a look back or something like that. Or is it once they get this authority, it's just in place indefinitely?
Yeah, Mr. Chairman. Yeah, there's no look back provision in this section or in the bill. It would be the charter would be granted, and then whenever either by the end of the year or if the commissioner adopts the rules and regs, at an earlier date, then beneficiate would be able to start transacting business as a trust bank. But yeah, there's no look back in that section.
Okay, thank you.
Any other questions for David? Representative Lynn?
Thank you, Mr. Chair. I just have a couple questions regarding Section 9. I'm trying to look at the actual bill to see if it answers those there. It says that you have to maintain an office space and then engage or contract with at least 3 employees in a rural, in an economic growth zone. I guess I'm wondering is there a reason to define what kind of office space as far as the size goes? And if those 3 employees, it doesn't suggest that they need to actually be in that facility, they just need to engage with at least 3 employees? Is that something, oh wait, here I see suitable office space means 2,000 square feet. But maybe you can answer about those 3 employees. Do they need to be on site?
Yes, Mr. Chairman, the employees would need to be on site, or they have to be in somewhere in Kansas within that office space, because they're there for the facilitation of any examinations, like if the bank commissioner's staff, examination staff comes, to make the examination, somebody would need to be there to provide the records and like that. So yeah, they would have to be on site. Some, at least, probably, I don't know if all 3 would have to be there every time, but there would need to be somebody on site in an office space for those examinations.
If I may, Mr. Chair, I guess my question is if those 3 employees could be essentially spread throughout the state in each economic zone. I would hope that there'd be 3 for each, or at least 1 for each, that they're not spread out to every single county, those 3. Thank you.
But, Mr. Chairman, I think the 3 employees would be, each trust bank would have kind of designate one particular economic zone. So there'd be one economic zone per trust bank. So they would be, the employees of that particular trust bank would be in one zone.
Any other questions? If not, I know David indicated that a lot of the technical questions can probably be answered by our proponents. Any final questions for David? If not, thank you, David. And we'll go quickly. Melissa, if you can give us kind of a breakdown on, I know we received a fiscal note on this, and then we'll see if there's any other questions.
Thank you, Mr. Chairman, committee members. As David has described a comprehensive bill, there are a number of state agencies who provided response to the inquiry from the Division of the Budget, and there is comment from 4 state agencies as well as the Association of Counties. The Office of the State Bank Commissioner indicates with that language regarding the pilot program that there would be 1 technology-enabled trust bank that will be chartered and examined in fiscal year 22, and it would be subject to the fees that are outlined in the bill. The office estimates in fiscal year 2022, it would receive $1.125 million into its bank commissioner fee fund, and then it explains what would come from both the initial fee and from the annual examination fee. The department, however, wasn't yet able to estimate expenditures that would be associated with the regulatory role in terms of new forms, its application process, performing the examination. But it said that those would be paid with additional revenues received from enactment of the bill. The second comment was from the Department of Commerce. The Department of Commerce states it would require $90,300 in fiscal year 22 from the State General Fund and $85,300 in fiscal year 2023 from the Technology-Enabled Trust Bank Development and Expansion Fund that's created in Section 24 of the bill in order to staff and manage this new fund. And then there is a breakdown of what those costs would be associated with an additional 1.0 FTE positions, both for fiscal year 2022 and fiscal year 2023. The agency does state it does need an appropriation from the State General Fund to finance expenditures until there is sufficient funding in this new trust fund. Also, there's comment from the Kansas Bureau of Investigation relevant to the additional state and national criminal history record check requirements in the bill. Those are found in Section 2. And the KBI estimates any additional expenditures created by the bill should be offset by revenues received to perform the checks by staff and the maintenance on required systems. The Department of Revenue also submitted comment. The Department of Revenue indicates the bill would decrease state general fund revenues in fiscal year 2022 by an unknown amount, and that's associated with the income and privilege tax credit David described in Section 28 of the bill. The department also makes comments regarding programming costs and resources that might be needed if this bill and other similar bills advance from the legislature. Finally, the Association of Counties states that the bill could impact Harvey County, since that county will be the first economic growth zone, and that relates to the question presented by Representative Berquist. That's the pilot program language in Section 25. If additional businesses are drawn to Kansas as a result of the bill, the association indicates there could be a fiscal effect on those counties as well. However, that effect could not be estimated at this time. And Mr. Chairman, that is the fiscal note for House Bill 2398.
Melissa, any questions for Melissa? I don't see any. Thanks, Melissa. And we will move in now to our hearing, and this will officially open the hearing on House Bill 2398, and would like to welcome the beneficent company from Dallas, Ben for short, and some individuals from the Heston community that will be proponents on this bill. And there is a slide presentation, so we'll do it a little different today if can. The slides are coordinated with individual presenters, so after I introduce the first presenter, then if each of those that follow with your slides, if you could introduce yourself and state who you're with for our minutes, and then you can just continue on this way, and we won't break it, because I know we're on limited time. We're going to try to get this in 45 minutes, including any questions. So we'll get started, and I think maybe that will help us kind of roll through it a little better. So to begin, our first presenter is Brad Hebner. He's the Chief Executive Officer and Chairman of TEFFI, which is I'm not sure exactly how that will be pronounced, but it's got a nice ring to it, and the beneficent group. And so, Mr. Hebner, a Kansas native, welcome back in for another visit to our state, and I'll let you take off, and then we'll just move through it from there, and we'll do all of our questions at the end.
Thank you, Chairman Kelly. I appreciate your holding this hearing for House Bill 2398. Thank you to the Vice Chairman and all members of the committee for giving us your time today to listen to our testimony. I am Brad Hebner. I'm the founder of the Beneficent Company Group. I'm the Chairman and CEO. We are based in Dallas, Texas, and I'm here today with 4 colleagues from our company. One of those colleagues lives in Heston, Kansas, and we're also here with our mayor from Heston, Kansas, out of Harvey County. My colleagues from the company who will be speaking today have worked with me for over 20 years each. And then the one that lives in Heston, Kansas has been my colleague and family friend for over 55 years, as has our mayor. We all grew up together in Heston. People ask where I am from. I say I'm a Kansan who happens to work in Texas. I'm a 6th-generation Kansan from Harvey County. My family settled an area called Highland Township between Newton and Heston, Kansas. My great-great-great-grandfather constructed our church on a prairie there, which is now a cornfield. When I grew up, it was our wheat fields. And it's in that church that 100 years of grandparents have been married. My parents married, my sister married, and my wife and I have been married, and we will be buried in the cemetery in my aunt's cornfield behind the church. About a section over from that church, I operate a generational grain farm that's been in our family, assembled by my great-great-grandfather. I've held that for over 20 years. And I've owned businesses, operated businesses in Newton, have commercial real estate in Heston and residences in Heston as well. So I'm a Heston Kansan. The youngest members of our family are my grandnieces. They are 8th generation Kansans, and they are the oldest continuously living family since Heston was founded in 1881 in town. Those are my grandnieces. They're in 5th grade in the Heston public school system. What we're going to talk about today is a trust banking bill. But working with the KBA, we're going to call it a fiduciary financial institution. There'll be one change we'd make in this bill, and I'll explain as we go. So we call that fiduciary financial institution, FID-FIN for short. The bill, Technology-Enabled Fiduciary Financial Institutions, we call TEFI, as a simple, catchy name as the chairman mentioned. I work in Dallas, Texas with a company called the Beneficient Group, but when I left Heston, Kansas, I went to college and then I went to New York City and I worked on Wall Street for one of the nation's largest banks, Goldman Sachs. And from Goldman Sachs, I went to Chicago and worked for one of the nation's 3rd largest financial institutions before I moved to Dallas, Texas, where I started and as an entrepreneur started my own financial institution. So I am a banker by background since the age of 22. I started several different companies, and then I've sold most of those companies to some of the biggest financial institutions in the world. Lehman Brothers bought one of my flagship companies from me about 6 years before they went bankrupt. We're not the reason they went bankrupt. We're actually the reason that they survived parts of bankruptcy. Mitsubishi Bank out of Tokyo, called here in the United States. They operate as the Mitsubishi Union Financial Group, MUFG. They bought another one of my companies, which still operates within our building. So I'm a banker by background. Today, I run and operate a company I founded called Beneficient. It's a trust company. And it operates, it's to be a trust company. It's a trust administration company. And it is in a growing industry. And I want to compare it for you to South Dakota. Years ago, when South Dakota focused on the credit card banking industry. If each of you pull your credit cards out and look at the back, it's processed through Sioux Falls, South Dakota, most likely, 90% chance. 9 out of 10 of you, your banking on your credit card goes through Sioux Falls, South Dakota because of their state legislation. Legislation like we're proposing here in House Bill 2398. Now, in our business, we do 3 lines of business, and it's pretty simple. We provide administration and accounting services to trust companies who have assets in trust when they can't do it themselves. That's number 1. Number 2, we provide trust services to business trusts. Those are different than regular trusts that you may set up for your kids or that your grandparents may have set up for you. They're business trusts. And number 3, we lend against assets that are held in business trusts. Our clients of our bank are rich, of our company, are rich people. They're worth over $5 million each. We don't have any clients in the state of Kansas. Our clients are spread out across other states across the United States. These folks set up these types of trusts and then turn to Beneficient to receive financing from Beneficient. Our clients expect us to be regulated in each of these 3 lines of business that I just went through. Unfortunately, no state has regulation that covers all 3 lines. So as a result, we have to operate in Texas under one line. We have to have a business unit up in Delaware under another line because they have the legislation there. And in our 3rd line of lending, we now have to look to operate in either South Dakota, Wyoming, or Nevada, or potentially Utah. Those are the 4 states that provide regulation and legislation to cover that 3rd line of business. But no state covers all 3. Yet regulation is clearly spelled out in these 3 different states for us to operate. So as a result, our company's clunky, inefficient, and it's tough to operate across these different states. Now, we went to, when our clients requested that we have our lending line regulated, we began working with South Dakota because we're one of the biggest in the country. But they're 1/3 of the population of Kansas. They're only 1 million people, 950,000 people in South Dakota. So we call up the biggest bank in early December, biggest law firm in early December, who specializes in having firms like us move in and become regulated in that state to permit us to do business. And we work with them. And what we learn is that we're going to be welcomed into the state. But there's 3 conditions. We would have to move about 50 of our employees to Sioux Falls, from out of state into Sioux Falls. We would have to either build or own a building in Sioux Falls. And most importantly, the economic contributions that our clients make, which is about 2.5% of their assets they put in trust, would have to be dedicated to initiatives within the state of South Dakota. So we'd have to move employees, we'd have to build or own a building, and that 2.5% of our clients' assets would have to be gifted in to initiatives within the state of South Dakota. Now let me give the context of that 2.5%. Last year, that amount was $12.5 million just from our company. We've held that money in escrow. It's sitting in an escrow, ready to be deployed, and it needs to be deployed for IRS purposes for our clients to receive a very valuable tax deduction that's worth 5 times that amount that they pay. So put it in the context of going to a grocery store. You're the customer at the grocery store, you buy a carton of milk, you pay a sales tax, but the grocer collects it and remits it to the state. That's what we do. We charge a 2.5% required contribution on the assets of the clients that put in trust. We collect that amount, and then we remit it to the jurisdiction of our operation, because we can't hold that money. Otherwise, they don't get the full 5 times tax deduction, okay? And this is our business and our competitors' business across the country. So, in those conversations with South Dakota, I have a Saturday morning phone call, standing phone call with my mother who lives in Heston. She's 80, almost 81 years old. And fortunately, she's still with us. She was 14 days in ICU at Newton Medical Center with COVID and survived. And I'm on the phone with my mother in December. And I said, listen to this. I'm going to have to build a building or buy a building in Sioux Falls. I said, we're going to have to right away move $12.5 million out of that escrow into South Dakota, and we're going to have to figure out which of our 50 employees are going to move up there. And my grandmother says, well, if you can do all that in Sioux Falls, can't you build me a grocery store here in Heston? So let me give you a little background on the grocery store, because that's when the light bulb went off that started House Bill 2398. When I grew up in Heston, Kansas, when I was in middle school, we had 2 grocery stores, we had a flower shop, we had a 5 and dime, we had a butcher shop where you went and got your chicken and you got your sausage. We had a bakery for cinnamon rolls and raisin bread. In fact, I worked there after school. By the time I was a freshman in 1979, in high school, we had 1 grocery store. Now, that's not Walmart. Walmart didn't cause that. Walmart did not come to McPherson until the late 1980s. Walmart did not come to Newton until the late 1990s. It wasn't Walmart that caused this. It was the agricultural industry. We may all remember the farm crisis. Heston is a large manufacturer of farm equipment. Farm economy, the farm industry took a nosedive in 1979 and 1980, led by federal legislation and federal policy. We all felt that here in Kansas. I felt it as a high schooler. Legislation impacts an industry. It can devastate an industry like Heston's. Main Street got shut down due to farm policy, or it can create an economy in a small rural community like Heston used to have under the ag industry. And that's what House Bill 2398 is about. I woke up after that call with my mother, and I called Derrick Fletcher, our president and chief fiduciary officer, and hey, Derrick, what if we figured out how to write a legislation that took the best legislation from Delaware, best legislation from South Dakota, best legislation from Wyoming and Nevada, put it all together in one so we could operate under one state jurisdiction, one place, all 3 lines of our business. And what if we took that 2.5% tax, which for us is anywhere from $10 to $20 million a year. I call it a tax, it's a required contribution. We took that amount, that $10 to $20 million a year, and we dedicated it into that state and the initiatives of that state. What do you think would happen? And his response was, all of our competitors would have a deep, deep interest in doing their operations in that state, but they're not going to want to move there. The employees aren't going to want to move there like South Dakota. And I said, I agree. I said, instead, we do our business over technology platforms. So isn't it more about moving the money into the state so that these funds benefit the residents of the state as opposed to moving employees into the state? And we all thought this had legs. So I flew up to Heston the next day on a Sunday, and I called Keith, who works for us over here, and I said, Keith, I want to sit down and talk to you a little bit. And I went over on a Sunday afternoon, and he said, let's get a hold of our mayor, Dave Kaufman. We all went to high school together, and that afternoon, we're in Keith's living room, and we're talking about how do we create a bill in Kansas that takes all these other existing written legislation from other states under one bill that's already regulated in other states, but move that economic benefit all here inside the state. We've got a tangible proof of concept, cash sitting in the bank, ready to be deployed in Kansas counties here in the U.S. And that led to lunch with Representative Owens, and the process began. Now, part of that process was meeting with the Kansas Bankers Association over the past month and had meetings with over 45 Kansas bank presidents and development officers from state banks here in Kansas. Each of those meetings over 2 hours long, and talking about the aspects of this bill that David, the reviser, had drafted up for us. And the conclusion from that was that we're not like the traditional banks here in Kansas. So I'm going to turn now to a few of the slides that we have. I'm going to start with the first slide up here and show you what we do, and then I'm going to compare it to what current banks and trusts in Kansas do. On this first slide, you may have seen, we have about 7 or 8 dark circles. Those dark circles are the cities where over 90% of people with worth over $5 million live. That's where we do business. But we don't see those people because their banks in those states bring them to us over a technology portal. That's how we do business with them. What House Bill 2398 does is it has them set up trusts in the state of Kansas. So that money comes to Kansas. Then what it does is it has that 2.5% of the asset base that these clients pay, and they have to pay that not to us, but to a jurisdiction in which we operate, be funded into the what we call the economic growth zones of Kansas. And what we did is we modeled that after the Rural Opportunity Zone legislation. So that money would come in to the rural opportunity zones, into the communities in those zones, for the communities to put that money to work, building a grocery store, funding their public school system, being able to do work with their senior centers and retirement communities and health facilities, and so forth in those zones. Our example is, we would be in the bill, we would be required to fund $9 million this year to our first economic growth zone. Now, we slipped Harvey County in there and Heston, Kansas into the economic growth zones because that's where we're from, and that's where we want to operate. It's where my family lives. And so that $9 million would come right in, build that grocery store, be put to work in our public school system with some additional improvements that need to be made in the public school system and recreation system and infrastructure of Heston, Kansas, and begin to reopen Main Street back to what I remember it to be when I was a kid. We're only one company, and we're one of the smallest companies in the nation in this space. We do this legislation the way it's drafted, prove it out through the pilot program, and we will attract other companies into the state of Kansas, just like South Dakota did in the credit card business, just like Delaware did with limited liability companies, just like Utah did with industrial banking businesses, and just like Nevada is working very hard to do with IRA individual retirement accounts. So this first slide shows money from outside of Kansas coming to Kansas. The funds, then, the 2.5% of the assets funding our economic growth zones here in Kansas. We're not taxing Kansans. So I want to address one thing I heard here about the privilege tax. It's very important that Kansas not feel any cost. And so the legislation is written that these funds have to be greater than the privilege tax. It has to be the greater of the privilege tax or this economic growth contribution. Now, the issue is who gets the money. Does that privilege tax then go to the county, or does it go to the state treasury? And that's something that could be addressed in the bill, that a minimum needs to go to the state treasury equal to the privilege tax. We hadn't thought of that. But that could be inserted into the bill, with the remainder going to the economic growth zones. The reason is, we call them economic growth contributions. The economic growth contributions will far exceed the privilege tax. My calculation is each year at least 6 times the privilege tax. So I don't want to hear that the state treasury will maybe decrease on its revenue. That is not the intent behind the bill. It's not the intent to dip into any regulatory agency. The intent is to fund them without having to tax Kansans, without having to look to Kansans' assets to do it. Let's use those rich people's assets moving into our trusts here. Just like your credit cards and all that financing, your credit card is run through South Dakota. It's the same example. Let's go to the next slide. Now, working with the KBA and 45 bank presidents and banks and so forth, they came back and gave us 2 comments. First, which I like both. First, traditional trust banking in Kansas started in 1897 and was revised in 1947, 75 years ago. And then there's been amendments and adjustments over the last 75 years to improve it. And that's the right-hand lane on this slide. Trust banking is relationship. You go in, you know your banker. Your banker is from your community. You trust them, you transact with them, they hold your hand, they help you. It is community-focused and geographically focused. The blue one is what KBA calls the new lane, or the additional lane in banking, which is represented by House Bill 2398. Ours is transactional based. You'll find this funny, out of all the clients we have, I've probably met 2, because all the rest come through our portal through other private banks. We don't know our clients. We transact in the trust industry through a portal. We're technology-based. That's why the bill starts with technology enablement. We focus on the nation. We have to focus in those 7 city centers where the rich people are, because our clients, by SEC standards, by the Securities and Exchange Commission standards, have to be worth over $5 million. Now, we operate with a full set of well over 60 policies, just like we probably have more policies and procedures than any community bank or trust company in the state of Texas. Than your biggest bank, Emprise. We probably have the same amount, if not more, policies and procedures for banking commissioners to be able to test and study and examine us. So this shows the 2 lanes that work side by side. We're complementary in business. We actually, and we're going to have one speaker today, James Silk, who's going to talk about the complementary nature. Let's move to the next slide. Who bears the cost of a TEFI? Okay. Well, it's not Kansas, because as I said, the bill should make sure that every regulatory agency has the funds they need through the fees that are charged to the TEFI, our company, and companies like us, or through the 2.5% that the customer, the out-of-state customer, pays. So it's not the state of Kansas. Number 2, it's not the beneficiaries of the trusts, because what the beneficiaries of the trust receive are the financing from us. That's why they're called beneficiaries. They benefit from the financing we provide to the trusts. It's not depositors, because I want to be very clear to everyone, we're not like a bank. We don't take deposits. You cannot deposit your money at a TEFI. It's non-depository. So no risk of losing a CD or a checking account deposit. So the parties that have the economic risk are the shareholders. We have $2.5 billion of capital in our company that have been contributed by our shareholders. They accept the risk of our operations, of these costs, and how we do business, and the reputational risk. I'll pause a minute and let you know that my board of directors includes 2 former Federal Reserve Bank chiefs, the former CEO and chairman of the Dallas Fed and the former CEO and chairman of the Atlanta Fed. I've always had Fed Bank chiefs on my board. Both those Fed Bank chiefs served under Bernanke on the U.S. Board of Governors, Federal Reserve, during the financial crisis. Managing and operating our companies and our operations are paramount to having stability, safety, and soundness. That's a paramount focus to our board of directors. Let's move to the next slide. So safety, soundness, and stability is important. What happens, you don't want TEFIs to have financial crisis and put a burden on the Office of the State Banking Commissioner, the OSBC. We want to make sure that we have structured this legislation, which we believe we have done, so that we don't have any types of failures in TEFIs. So there's 5 main points to point out on this slide. Number 1, as I said, we're a non-depository institution. Can't deposit the money, so no depositor can lose money. Number 2, the legislation specifically restricts a TEFI from borrowing money, so it can't go to another bank and borrow. It can receive funding from its affiliates or from its parent company as a loan, but it has to be a sister or a parent company. So there's no bank that can lose money lending to a TEFI. Number 3, the TEFI must have an agreement, we put this into the legislation, from its parent company or sister company to deliver capital to the TEFI if it's needed for its operations, so it can keep its doors open. So there has to be a contract to provide for funding should the capital or the liquidity not be there at the TEFI to be able to make payroll and operate. Number 4, if a TEFI were to have any type of challenging, experience any type of challenging financial situation, it could then distribute its assets and whatever payables it has up to its parent, so that the TEFI itself would no longer have any balance sheet assets or liabilities. And number 5 is among the most important. The instruments that are the trusts permit the TEFI to resign as trustee with 30 days notice to the beneficiaries, and it puts in place a successor trustee that are individuals. Now, you're probably familiar, financial institutions, individuals as trustees are not regulated by a state or federal government. If you're an individual, you can be a trustee of a trust, probably have your own revocable trust, and you're a trustee of it. You're not regulated. And so what happens here is a TEFI could, the commissioner can request resign as trustee. The successor trustees are individuals, and they're appointed in. And then those successor trustees can hire other companies to do the accounting and administration to wind up those trusts. The important point of that process is that the regulated entity is no longer a trustee. And that allows the commissioner then to oversee and watch the closing down of the TEFI if there were any type of trouble without any financial loss to the TEFI or burden on the commissioner's office. Let's move to the next slide. This is the last slide I'll present, and then I'm going to turn it over for much briefer testimony from the other individuals. I took the most time, purposely. This slide shows just the economic growth contributions from the pilot program. The pilot program is very important. We knew that there is no way to write a comprehensive legislation was going to cover everything right away. And we also knew we needed to move quickly at putting legislation in place, because there's something called first mover advantage in business. All of the folks and entrepreneurs and so forth here, you know what first mover advantage is. You want to be the first one there, because then other people start to follow in. Other companies like Beneficient will follow in. So what we wanted to do was put together the legislation that was going to cover everything we know, and we operate in this space, and everything we know from working with other commissioners around the country, put it into this legislation. Then we wanted to put in a pilot program. We talked about the pilot program during some of the conversation. Pilot program is, let's get it up and operating with Beneficient. Beneficient needs to be chartered in order to operate. In order to do that, charter Beneficient. Beneficient works closely with the OSBC over the next 6 months, next year and a half, to make sure we get the right rules, forms, examination standards in place. We come back to the legislature if we see any amendments are necessary prior to opening up to the rest of the nation. Now, Beneficient needs to be chartered because in order to be chartered and operate in the state of Texas, that then allows us to conduct our lending business, which leads to the 2.5%. And that 2.5% immediately then comes into the economic growth zones. So for example, this first amount of, in the bill calls for $9 million. I happen to know it's probably going to be closer to 11.5 million that would be released once the legislation is passed in July. And that would go in, and the grocery store would start to get constructed this year. A year of financial deficits in the state of Texas. The residents of Kansas are going to see revenues coming from outside of the state, not revenues from Kansans, not taxes from Kansans, just after these big heating bills that we're all suffering from. No more burden on a Kansan. This is coming from rich people from the Palm Beaches of Florida, the beaches of Newport Beach, California, New York City, Chicago, Silicon Valley. That money's coming into our trusts. They're getting the financing they want, and their 2.5% is going to us as Kansans in our communities. This chart shows what we forecast, the immediate contribution of $9 million. I believe, as I said, is about $2 million short. In the subsequent year, next year, which is this year, 2021, we're already on target for another $10 million. In the next year, we are forecasting another $10 million, and in the next year, about $15 million. We're one company. We've got 10 competitors on our heels at all times. Beside those 10, you have 8 very large New York Stock Exchange and NASDAQ traded companies that will set up divisions with clear, concise legislation like 2398, where all elements from these other states are packed together in one piece of legislation. And we have the opportunity to become the FID-FIN location of the United States, just like Sioux Falls with South Dakota, with a population of 1/3 of ours, is the credit card capital banking of the world. We can be the FID-FIN world, banking of the world. There's over $2 trillion of assets held by individuals and institutions in the United States that look to transact this type of business. We use that pilot program to get it right with the commissioner and beneficent. We use that pilot program to adjust the legislation where we see it's necessary. We stay the first mover advantage. We don't wait a year. We don't wait a year and a half. We go to work right now, and we get this moving. We get that $10 million moved this summer, and we show the impact to residents of what we're wanting to do. And we preserve that first mover advantage as the place with the statutes that can do business with companies like Beneficient, some of the biggest New York Stock Exchange traded companies in the United States. Now, let me make sure I covered everything. The last point I'll make is I'm really impressed that we have financial institutions and rural development in one committee, because that's what we're talking about here with this legislation. We're talking about creating TEFIs that are subsidiaries of big companies spread across the United States in our rural communities, and taking that money that otherwise would go to other initiatives in other states and applying it right here in our rural communities in Texas and hometowns like Heston. I'm going to introduce to you next Derrick Fletcher. He's the president of Beneficient. He's chief fiduciary officer. He's worked here in Kansas. I've had the pleasure of working side by side with Derrick for over 21 years now, and he's worked very closely with David, the reviser, and certain other folks from the legislature, and this is Derrick Fletcher. Thank you, Mr. Chairman.
Yes, thank you, and Derrick and all that follow you. A lot of pressure on you because we're down to 6 minutes and 8 seconds left to go in the 45 minutes. So,
Mr. Chairman, thank you for that. I will keep my comments brief. Thank you, Mr. Chairman, Mr. Vice Chairman, and members of the committee. Again, Derrick Fletcher. I had the privilege of working in Kansas when I was an executive with Bank of America before joining Beneficient Company Group. What I'll point out to you just briefly here is, as Brad mentioned, there is no state that has consolidated legislation regarding our industry. What we've put up on the slide for you today is the states from which the statutes that you will see in the bill were derived from. Over 70% of House Bill 2398 is derived from existing state statutes. So 70% of what you heard David reference when he went through the bill is derived from existing state statutes. The remaining 30% is attributable to really the economic benefits to the state of Kansas and to the economic growth zones. We talk about this being a new lane in financial institutions. Think about the development of an HOV lane. Construct an HOV lane, same road, same materials, same infrastructure, right? Complementary to existing lanes. The lane moves a little differently, right? Different traffic patterns, but it's the same road, subject to the same traffic laws. So let me tell you what a TEFI is. At its core, a TEFI is a trust company, subject to the same rules, regulations, duties, principles, fiduciary responsibilities as a traditional trust company. Same road. Subject to oversight and examination by the commissioner in the OSBC. Same traffic laws. We are subject to the same criteria, the same rating systems as a traditional bank and trust company. The CAMELS rating system, for example, that tests the stability of a financial institution. We would be subject to those rules. Right? It's a matter of how do those traffic laws apply to this particular industry. And that is really the benefit of the pilot program. Right? The pilot program gives us this risk-free period where, one, the commissioner and his staff can evaluate TEFI business. They can determine how will these traditional examination principles apply to this new institution. Second, as Brad mentioned, it gives the pilot program TEFI the ability to partner with the OSBC, with the commissioner's staff, with the intention of providing policies, procedures, standards, controls, collaborating with one another to make sure that the regulatory environment, the examination process is custom to this particular lane of financial services. And then third, and importantly for this body, the opportunity for the legislature to oversee, to monitor the maturation of this pilot program and to make adjustments through legislation as may be necessary to enhance, improve, refine the TEFI statutes before it's opened up to other participants in this industry. So one thing that I would highlight is this is our ability to form this lane today, drive the economic benefits that Brad referred to into Kansas, test drive this lane through the pilot program, working with the OSBC, refine, enhance, improve the statutory construct, and then open it up to other participants. So in closing, this new lane, I am convinced this new lane is going to be created somewhere and sometime soon. And the question is, why not here? Why not in Kansas? Why not create this new lane here so that Kansas becomes the South Dakota of credit cards, the Delaware of business organization, right? Driving economic growth into our rural communities. So why not here? I would encourage you to study 2398. Certainly we're available to answer questions about it, and would encourage you to support its enactment. So thank you for your time. I'm going to turn it over to James Silk to talk about the complementary nature of the business. Alex, I'm sorry I didn't go through the slides, so apologize.
Mr. Chairman, with respect to the committee's time and the schedule, I'm going to go ahead and yield my time to Mr. David Kaufman, Mayor of Heston. I think a lot of things I was going to discuss have been covered. I want to be respectful of the committee's time. Thank you.
Good morning. My name is David Kaufman. I want to thank Chairman Kelly and all the members of the committee for allowing me to speak this morning on behalf of HB 2398. I had some things written down, but I guess what I'd like to say this morning is I'm very proud of where I come from. As you can tell, Brad is proud of where he comes from. And I live in a small town. We're about 3,800 people. So if you think of where you came from, everybody here represents a different part of the state. And we all have needs. And what we don't have enough of most of the time is financing. And there are so many things that we can do with our schools, with our, yeah, I think of Heston, we're kind of a bedroom community. We've lost, as Brad said, you know, our grocery store. We've been working for the last 3 years trying to figure out how to finance a $2 million grocery store. And then this month, in a 4-day period, we got a bill for $5.3 million with a gas bill. So we all have challenges, and Heston is blessed in many ways. We're on the interstate, we've got a beautiful college, we've got, it's just we're proud of it. But you're proud when you're from Western Kansas or when you're from the north part of Kansas. We all have so much to offer, but we need money. We need the opportunity to enhance our quality of life. So I would just ask you to strongly consider this bill and what it could do for the state, because as Derrick just said, this is going to get done somewhere. And if it's not here, it would be kind of a shame. So thank you.
In respect to the time, we do have a couple other brief presentation, or we can cease and take questions and answers, Mr. Chairman.
What are the presentations you'd like to do?
The one that really relates to TEFIs would be the comparison of how a TEFI is complementary to existing state trust and banking companies in the work we did with the KBA. And then the other one is Keith Martins, who is a beneficent development officer who lives in Heston, to explain how the funds would be administered locally, like under the ROS programs. Those are the two. Or we can take question and answer at your direction.
Why don't we take question and answer right now, and we'll see, because we're down to, we're about a couple minutes over now of the total time period.
Okay.
And then we can, maybe they'll work into those questions.
Okay.
Committee questions, Representative Wassinger.
Thank you, Mr. Chair. Stupid question. If you're going to invest in the community, where does what if the grocery store doesn't work out? So who's the loser in that? Is there a payback? Is there?
No, there's.
How do you?
Yes.
I'm just confused.
Okay, so that was part of what one of the, I'm going to cover, Mr. Chairman, one of the presentations in this answer, because this, one of the presentations was focused on this. The view would be that you would form community foundations. Many towns have community foundations. I was the founder of the Heston Community Foundation about 15 years ago with an initial contribution there. So other towns would form what we call a community development foundation made up of the community leaders. The money is gifted into those foundations by TEFI clients. So the money shows up in the foundation locally, and the leaders of the governors of the foundation are the leaders of the community. It's the local bank president, it's the mayor, it's the community activists, it's the head of the school system, etc. And they're making the determination at the best place in combination with the city council. We have a 5-member city council in Heston, and how those funds are to be deployed. Those funds aren't to be paid back. So when that grocery store is opened, there's no one's owed any money back. It is owned by either the foundation or by the city, either one of those, the community foundation, and let's call them community development foundations, because many have a community gifting foundation. The one we set up in Heston was for the public school system in Heston to help supplement the needs of that school when the state budget got tight. So we're looking for the deployment by those local leaders through a foundation, and it would have the asset base and no liability, no requirement to pay back.
Thank you very much, Mr. Chair.
Representative Day.
Thank you, Mr. Chairman. I have a question about just reading through some of the documents that were sent out in preparation for this presentation. There was a mention that the Kansas Prudent Investor Rule allows for expansion, restriction, elimination, or otherwise altering the trust through the provisions therein. And in the second sentence of the subsection B of the Kansas Uniform Prudent Investor Act, it specifically states that the fiduciary is not liable to the beneficiary to the extent that the fiduciary acted in reasonable reliance on the provisions of the trust. So the whole point of the Prudent Investor Rule is that the fiduciary is acting in the best interest of the beneficiaries when controlling their investment portfolios. And I'm trying to understand a comment in that document that was sent to us that says, in accordance with this clear authority granted under existing Kansas law, the trusts of which Ben serves as trustee eliminate the application of the prudent investor rule and direct Ben to hold and administer the alternative assets. And maybe it's the alternative assets aspect of it that changes things, but can someone help me understand it seems like we're just dismissing our prudent investor rule that we have on statute. Thank you.
Thank you, Representative David. We have an expert here on that, and that's Derrick Fletcher, who's been a trust officer and an estate lawyer almost his whole career. He's Beneficient's chief fiduciary officer, and he's best suited to answer the question.
Representative Day, it's a great question, and you are correct that Kansas law provides that the prudent investor rule can be waived and eliminated. So I think it's important to think about the underlying assets. What the trust that Beneficient would manage or a TEFI would manage are alternative assets. So in the prudency rules or the prudent investor rules, you're thinking about diversification. Right? You're thinking about risk management. You're trying to avoid concentration in assets because you're exercising discretion in investing those trust funds. In this type of FID-FIN trust, as we refer to it as, it is a single asset that is concentrated. It's not easily tradable. And so what that provision does is it makes clear that, number one, the client is directing the trustee to hold that asset, to hold that concentration, and it's absolving the trustee from the prudent investor rule consistent with Kansas law, given the nature of the underlying asset. I agree totally with you that if the nature of these trusts were more traditional in their scope, where the trustee is given discretion as to investing client funds, that the prudency rules make entire sense. You want to make sure that you're investing and exercising that discretion appropriately. But here, it's a very narrow application, a single asset that is concentrated without really the practical ability to diversify. And so as a result, there's a waiver consistent, again, with Kansas law. I don't know if that's responsive to your question.
That answer your question, Representative Day?
Yeah, I think there's an overall concern that I have now with the state statute that allows for just a dismissal of the prudent investor rule. but I do appreciate taking the time to answer. Thank you so much, Mr. Chairman.
Thank you. And Representative Poskin?
Thank you, Mr. Chair. In terms of the first mover advantage, can you tell us if there are other states who are currently considering creating this line in their legislature? If so, where are they in the process?
Very good question, because there were not as of Christmas. But since the public filing of HB 2398 and Senate Bill 288, we've gotten feedback from other law firms that other states now are studying it to figure out whether or not they need to jump on first. What happens in this is just like in Delaware. When a state moves, and in South Dakota, and in Utah with industrial banking laws, when a state moves first, and this was one of the reasons for the pilot program, when a state moves first, you can't think of everything. You just can't. There's going to have to be adjustments as we move along. We're going to have to work with the Office of the State Banking Commission to apply their existing examination standards to what we do, and the CAMEL ratings to what we do. There are parts of the legislation that address that. But you got to move first, because if you don't, Utah will, or South Dakota most likely will. So we're being reviewed right now by other states because it's posted on the websites. And you have associations across other states looking just for this, trolling and looking. And 2 months ago, 3 months ago, I've been able to say, no, we're going to be about the first out there. But now we're not.
Thank you very much. Thank you, Mr. Chair.
Representative Hsu?
Thank you so much for being here. I think a lot of people here have talked to me about ambition, and certainly this is an ambitious bill, and I appreciate that, certainly. My question is kind of related to roughly the economic growth, right? And so my concern and my question is, how do we make sure that the pilot program doesn't end up just essentially becoming a barrier entry for other TEFIs to walk in? You know what I mean?
Yes. That's a good question. So when I entered my first company that I bought, there were only 26 in the industry back in 1995 and grew. It was a new industry, just like the TEFI area is just now starting to grow, okay? And what happened is one of your biggest banks came into the industry about 2 years into my business, and I learned something really important in business. When you got good competition that comes in, that's big, that comes in, it grows the industry. The whole industry grows, and my company got bigger. We got very large because Goldman Sachs came in, Morgan Stanley came in, Merrill Lynch came in. You want competition. The bill has got to be focused on bringing in other TEFIs. So that's why the bill includes an allocation to the Commerce Department. If it's not enough for the Commerce Department, and if they're coming out of pocket anything, we need to up the amount to the Commerce Department because it's the Commerce Department's role to help bring in other TEFIs when we get it right, to bring it in and bring competition. We'll grow. We'll do just fine. Always did. We know, and all of our good competition know how to grow at the same time. Ask any of our executives at our company, I always promote, we want competition because we grow. The whole industry grows. Now, when the Commerce Department goes out, we kind of model that after what Texas does. Texas keeps a condominium in Silicon Valley, California, and expects its governor, this started with Governor Rick Perry, the longest serving governor of the state of Texas, it expects Governor Abbott to spend time at that condominium convincing technology companies and California-based companies to move to Texas because of the great tax situation we have in Texas. Come on to Texas. So that's the concept behind the funding of the Commerce Department. We need to encourage competition to come in and grow the economic growth zones.
Okay, thanks very much. And Representative Owens was listed, but he's going to yield his time to the neutrals. And so I show no written proponents. Is there anyone else that would like to briefly speak as a proponent for this? I know there's lots of questions still to be asked. I've got a couple pages full of questions, but we need to get on in this. So would like to close the proponent portion of the hearing and open the neutral portion of the hearing. And the first speaker in our neutral portion is David Herndon, Bank Commissioner for Office of the State Bank Commissioner, and Commissioner Herndon, I think, is going to come in from the other room. So, morning, Commissioner. Thank you for being here.
Morning, Chairman Kelly, members of the committee. Thank you for the opportunity to appear as a neutral conferee on HB 2398. My name is David Herndon. I am the Kansas State Bank Commissioner. Early in this session, Representative Owens and the proponents of this legislation met with me and my staff about their proposal. We appreciate the time they took to explain to us their unique business concept and to involve us up front on this legislation. We are neutral on this bill, as our office does not decide policy. We absolutely respect that we are regulators and you are legislators, so if you legislate, we will regulate. But if called upon to be regulator for this new entity, we will do so, but have to say to this legislature and go on record saying that we have some concerns. Notably, we are concerned about the following. Neither our office nor others in the bank regulatory industry fully understand this business model today. Therefore, we cannot make realistic or reliable conclusions as to the likely success or failure of this entity. And as you've heard, the entity is unique to the Kansas market. The entity's lending practices relies on alternative assets, such as venture capital funds, private equity investments, and private real estate funds, all of which are defined as illiquid and therefore generally considered volatile or unstable in terms of generating sufficient cash flow to service debts. Because the OSBC is not accustomed to examining these types of assets, there's no historical data or modeling that has yet been developed that demonstrates the expected cash flow trends and levels of debt service or profitability for these during an examination by our office. The bill does not allow OSBC to review the profitability of the entity during examination. It's our position that an entity cannot be successful without generating profit, and that probability is a necessary component to any examination. Furthermore, the bill creates additional exceptions to our typical examination processes for financial institutions. These are not just the OSBC's typical processes. These are the industry standards across the country. The standard formulas for financial metrics, capital requirements, concentration of risk, usury rate, unusually high compensation, conflict of interest, all are modified, and an exception to GAAP, generally accepted accounting principles, is included. All these items would pose significant obstacles to the OSBC to conduct a proper safety and soundness examination. The entity is not FDIC, as you heard. It does not take deposits, so it is not eligible for FDIC insurance. So if the entity doesn't succeed, will other entities step up to take over the operation? We don't know. Does the OSBC have the authority to close or to resolve its issues like we do with failed banks? The first is a pilot program before others are allowed in the state. To us, the approach indicates an experimental concept which raises the concerns for any financial regulator where conservative, prudent measures are generally followed. So I'm happy to answer any questions about the OSBC's role in this, and I appreciate the committee's consideration of my comments.
Thank you, Commissioner. And if we will hear our other two neutrals, and then if you're available, we'll direct our questions like we did in the first part to all three neutrals.
Thank you, Mr. Chairman.
Thank you very much for appearing today. Our next neutral testimony comes from Alex Orrell, Senior Vice President, Kansas Bankers Association. Welcome, Alex.
Good morning, committee. Thank you for the opportunity to be here today. Since this probably will be my last time testifying before this committee this year, I want to thank the committee's work this year on many pieces of legislation critically important. I am Alex Orrell, appearing on behalf of the Kansas Bankers Association to provide neutral testimony on HB 2398. As Brad stated earlier, we appreciate this committee's work looking at economic development initiatives specifically for rural Kansas. That's what this committee is for. We were first approached by the proponents of this legislation in December. And it did take a lot of education on our members front, and we spent a lot of times with the members, have been efficient, and frankly have been great to work with. I've answered every single question we have posed to them over the last 3 months, and have had many Zoom calls, in-person meetings that have lasted hours with bankers across the state, as well as members of our trust division, which has been around for over 100 years, as well as trust experts from the American Bankers Association, and finally with the KBA State Affairs Committee, which directs our policy here in Kansas. That is comprised of almost 40 bankers across the state, mainly bank CEOs, that determine what we do here before you. Our three major things I'll talk about today, and for brevity today, were our first issue that we thought about on this legislation was, is this going to compete directly with Kansas banks and Kansas trust companies? And if they do, are they going to compete on a level playing field? Something we always advocate before you. We have concluded that TEFIs would not directly compete with Kansas banks and Kansas trust companies. Frankly, it's creating another lane of financial service that could be complementary, just like banks and trust companies are to each other. The other question that arose was, does this disrupt the Kansas banking and Kansas trust business model? We do not believe it would affect our current business model negatively. And finally, our last point was the initial term of technology-enabled trust bank. We did have concerns with that term because they're able to do things that traditional trust companies and traditional banks are not able to do. It was not anything crazy with the idea. It's just you're able to do things we can't do. And they settled on the term because Ben is a trust company at its core, and they are doing lending practices on those assets. Trust bank makes sense. But we did have concern regarding it could pose confusion among potential customers as well as to the general public. And they did work with us on changing the name to Technology-Enabled Fiduciary Financial Institution, and we are comfortable with that. In conclusion, we do not believe it directly impacts the banking industry within our state. And we do believe this merits the policy discussion of this Kansas legislature and this committee to look at this issue that possibly could be complementary. So with that, Mr. Chairman, I do thank you for the time, and I'll stand for questions at the appropriate time.
Thank you, Alex. And our final neutral testimony comes from David Sofer of the Legislative and Policy Director for the Department of Commerce. Welcome, David.
Thank you, Mr. Chairman, Vice Chairman, members of the committee. David Sofer, Legislative Policy Director, Kansas Department of Commerce. I'll be short and sweet. I know we're short in time. Just to be really clear, we are not experts in alternative asset management or banking. So for that reason, we are neutral on this bill. But we're intrigued by the idea and believe it does deserve serious consideration here before we wrap up the 2021 session. We believe this bill would provide an opportunity to bring new dollars into our state, which is always something we really need to be able to capitalize on and should always welcome that opportunity. When you look at some of the things the administration's working on with respect to, the Framework for Growth or Economic Development Plan or the Office of Rural Prosperity, our commitment remains to our rural communities that we need to be able to continue that investment so they can grow, prosper, and really kind of create that vibrancy that our rural communities and those main streets need in order to be able to be successful long term. So from our department's viewpoint, those economic growth zones provide that opportunity to get some capital, and especially into those smaller communities that often face a lot of those greater challenges when it comes to development. So, whether you're talking about infrastructure, I know we mentioned a grocery store, that's a tremendous need in many of our rural communities, education, health, daycares, the like. That's real economic development in areas that need it most and can really tremendously impact a rural community, especially our smaller communities. So from that end, we're very excited about that prospect. And then again, at the end of the day, we're always looking for ways to be a national leader. So, if there's an opportunity for us to be first in something, kind of take on, an opportunity, whereas, the LLCs in Delaware, the credit cards as mentioned in South Dakota, we should always merit, those types of proposals deserve serious merit because it really can provide the opportunity for us to kind of be the leader and then be able to benefit from that both financially and with our communities as well. So from that end, again, we can't. The only reason we cannot be a proponent is, again, we're not experts in this field, but we do believe this committee should consider the bill, any concerns, and potentially acting on it here before session wraps up. And with that, I appreciate the opportunity to testify and be happy to stand for any questions.
Thank you, David. Appreciate you being here. Are there committee questions? Representative Burkamp.
Thank you, Mr. Chair. Mr. Herndon. Just a quick question. And the bill is able to find most of your points except for the exception to the gap rule. Do you know which one that?
In particular, the earnings component.
Okay.
If we were asked to sign a report that did not impact or assess the earnings side, it would violate the gap principles of the rule.
Okay, thank you.
Other committee questions? Commissioner Herndon, I have a couple I wanted to ask you. Reading through the bill and then having spent probably 15 years of my career working in compliance and working with the examiners, I was wondering, is it normal that you would approve forms and all that would be submitted to you and have an approval of those forms? Or it was, I don't remember it back in the 80s when I was doing it, but is that something that's practiced now?
Mr. Chairman, the OSBC does not draft forms, nor does it offer forms. We do, in the course of our examination, review the forms that the institution uses for compliance purposes and that sort of thing. And we will express an opinion if we find their forms have some sort of conflict with a particular typically a compliance issue, but we would express an opinion. But otherwise, no, we do not draft forms. We do not review forms for approval other than through the examination process, as I mentioned.
Second question that I had was, as I looked at the bill and the time frame, and then your kind of comments on the complexity and creating a new lane, as was described, which was a good description of it, I think, it's very aggressive. And is it reasonable to assume that the bank commissioner's office, if this legislation was passed, could meet that time frame to put rules and regulations and examination procedures in place and be ready to go with that?
That would be a very, very aggressive timeframe for my agency or, in my opinion, any other regulatory agency to meet. The research required does include background checks by law enforcement, including the submission of a fingerprint investigation that's conducted by KBI and/or the FBI for the directors and for the senior management of de novo entities in banks. Then the process of reviewing the business plan and the financial projections would also take time. So it would be a very, very aggressive, and I could not provide any assurance that my agency would be able to meet that time frame as proposed.
Are there some things in the bill, requirements that you may not have, or would you have the expertise to conduct the examination? I mean, I know you normally rely on some other regulatory agencies to do examinations of regular banks. In my experience over the years, would that be something that you would be able to do all in-house?
It would take all in-house. There is no availability to involve that we've been able to determine any federal agency like the Federal Reserve Bank, the Federal Deposit Insurance Corporation, or the Office of Comptroller of Currency, the three federal regulators that examine banks as well. FDIC won't do it because the entity does not accept deposits, and the FDIC is an insurance fund for deposits. The Federal Reserve examines member banks, and the OCC examines national banks. This is not proposed to have any national charter the way that we read it. So it would all fall to our office, and there would be some new policies and procedures that we would create for the examination process.
Okay. Any other questions for Commissioner Herndon? I have the same as I did with beneficent. I have another whole list of questions, but we're at the 10:30 mark, and so I want to see if there's any last questions or anything from our members. I don't see any hands up on the screen, but if there's any in the room. But committee, as we go, like I said, it's a very new and it's complex, and so I think we need to all reflect on what we've heard today, and if there's any other questions, we need to consider all that as we move forward with this, and. So reflect on the testimony of both the proponents, the bank commissioner, and our other neutrals, and watch your email on what our schedule will be for the rest of this week. But appreciate everyone being here today, making the trip to Kansas. I know you'll be back, I think, next week to be in the Senate hearing, but we will I show no other neutral testimony. I show no opponent testimony. Anyone wish to testify as an opponent? If not, we'll close both the neutral and the opponent portion of the testimony and we will be adjourned.